are, we have Maureen Nyatichi, Elizabeth Muya, Kate Njue, and Brenda Muchola. We will have some questions at the end of the session. That is after we have all the presentation, that is SHIF, NSSF, and affordable housing. However, we will be taking 2 questions after each session. So after, for instance, the SHIF will have 2 questions, after NSSF 2 questions, and after affordable housing we'll take 2 questions. At the end, however, we'll also take variety of questions. In case of any other questions, you can raise them on the chat, the same will be addressed. We will start by having the Affordable Housing Levy and Act in place. This will be handled by Elizabeth Muya. Elizabeth Muya is the Technical Manager at Taxpayers Africa Consulting, and she'll be in charge of the affordable housing. Elizabeth Muya, welcome to the session.
Good morning, everybody. Thank you, Diana, for the introduction. So my name is Elizabeth Muya. I will be taking you through the Affordable Housing Levy and basically the developments around the Act. So we will start from the initial introduction. We'll start from the initial introduction. So initially, the Affordable Housing Levy was introduced in the Finance Act 2023. So the Finance Act 2023 introduced the Affordable Housing Levy at a rate of 1.5% on monthly salary of employees, and this was to be matched. This was to be matched by the employer. However, this came into effect on 1st July. However, this was challenged. Basically, the key concern around the area was the element of discrimination. When it was introduced via the Finance Act, it only covered salaried employees. So again, the question was, why is the tax, it's not a tax, the levy being borne by just the salaried employees, while ideally taxes should be borne equally by everybody. So that was the first element of contention. So the next one was there was no legal framework again for the imposition, collection, and administration. So it went to the High Court and it was again declared unconstitutional. This was in November of 2023. So once the High Court declared that it was unconstitutional, again, this was appealed. However, this was appealed, but stay orders were granted. So if you notice, this was the Affordable Housing Levy was deducted in if you're employed, that is, this was deducted between July and December of 2023. The Affordable Housing Levy was being deducted. Again, this, despite being declared unconstitutional, there were stay orders in place. However, the stay orders expired on 10th January. The government again tried to get stay to be extended, but this was not granted. So the Court of Appeal again said that the matter was unconstitutional, didn't extend the stay. So again, the government was asked to hold off collection as this was not in public interest. If the levy was said to be unconstitutional, it was not in the public interest to continue collecting, despite the argument that the refund processing and stuff like that would be a challenge. So this was to be paused until the substantive elements of the appeal were heard. However, in the process now, the government started looking into how to reintroduce it, addressing what the challenges were. So this now led into the introduction of the Affordable Housing Bill 2023. So this went through Parliament. The several hearings were done, and on 19th March 2024, this was assented into law, and now what we have as the Affordable Housing Act 2024 came into force. So ideally, when the Act first came into place, the only sections that came into effect on that day were the charging section. This is section 4 and 5, which basically provide for the imposition of the levy. On 21st March, this was gazetted, and the effective date for the rest of the sections now was provided to be 22nd March. So ideally, with that now, the whole act is in effect and will automatically affect your March salary for employed persons. So the Affordable Housing Act imposed the levy to be at a rate of 1.5% of the gross salary of employees. This is to be matched by the employer. So, but now the element of unconstitutionality is tried to be covered in the next one. So now, income that is not from salaries is also subject to the Affordable Housing Levy. So at the rate of 1.5 as well of your gross income. So income that has been accrued in Kenya, well, not necessarily in Kenya, but income that has been accrued by any person now that is not subject to the 1.5 under salary will also be subject to the Affordable Housing Levy. Again, something that was not provided for initially when it came through the Finance Act is the relief. So the Act provides for a 15% relief of the employee's contribution, subject to a limit of 108,000 per annum. This is basically 9,000 per month. So this is 15% of your contribution, subject to the limit. So for the employer who's matching, the element their matching will be an allowable deduction for corporation tax purposes. So for the employment element, the Act provides for the obligation to be on the employer. So your employer for salaried people will be deducting and remitting. If an employer fails to deduct and remit, accordingly, they will be subject to a penalty of 3% of the unpaid funds for every month it remains outstanding. So again, this is something that employers need to look out for, because there will be a penalty for failing to adhere to the provisions of the Act. The due date is the ninth working day after the end of the month. So this will be same with your pay as you earn, NSSF, the rest of the statutory. So by the 9th day of the following month, the housing levy will be remitted to the carrier, because the carrier again is the body appointed to be the collecting agent. So the Act has provided for exemptions. So the first one is where an employer matches the contribution of their employees, they will not be required to basically account for Affordable Housing Levy. The next one is that the CS for affordable housing, this is the CS lands, can recommend to the National Treasury CS for exemption on various incomes of persons, and again, subject to his discretion, he may grant exemptions under the Act. So the Affordable Housing Act provides for four types of funds. So the first one is the social housing unit. This is for the low income earners. So anybody earning anything below 20,000 will be covered under the social housing unit. Then affordable housing unit will be for employees earning, well, not employees, persons earning between 24,000 and 149,000. So previously, when the Affordable Housing Levy was introduced by the Finance Act, there was no provision for people earning over 150,000 to get a unit. However, the Act provides for the affordable middle class housing unit. So anyone that is earning anything above 149,000 will be able to get a unit under the Act. There's also a provision for the rural affordable housing unit, which is basically for people residing outside of the urban area. A few people have asked about what happens to the people, these various lands that the government has picked as part of the affordable housing agenda. So the Act provides for what will happen in these instances. So if the government picks a settlement as part of their allocation for the affordable housing unit, they will have to notify the residents of that settlement. So notice of intention to develop will be provided. Then they will also have to, the board now will have to set up the mechanism for resettlement. So you might have had the government saying they will offer 2-year salary. So this is basically what is being covered. So it's under the Act, under the setup for mechanism for resettlement. Then they will also get the priority in choosing a unit. So they'll get, they'll have the first option to actually get a unit. Okay, so the Act also now provides for voluntary savings. This, you might have, if you've gotten a unit, you might have experienced this in your e-citizen, where you might have saved for that. But now the Act now brings everything into, wraps everything up nicely. So now it's provided for in the Act. So a person is allowed to make a voluntary savings for a unit. So you can do your own voluntary, there's a difference. So you have to note that what is being contributed as the levy does not guarantee you a unit. However, for you to get a unit, you can now do your voluntary saving for the unit. So what happens is that if you do not get a unit, you can opt to withdraw your money and any accrued interest. So to do that, you'll have to do a notice to the board, write to them, have a 90-day period, let the board know you're withdrawing your amounts, or you can get a mortgage to develop in the rural areas. So if you're building a house in the village, you can take advantage of that and use the affordable mortgage. So your savings up to then and the land that you're going to develop on will be used as collateral for the affordable mortgage you're getting from the government. So how do you get a unit? So basically, the regulations which are yet to be published are what will give insights into what is the eligibility criteria on getting the unit. These are yet to be gazetted. So once they are out, they will provide the mechanisms of how everything now will come into force. Another thing is that the Act mentions that the application is to be done by a natural person. However, in the application procedures, it alludes to also corporates being able to get a unit. We'll see whether this will be clarified further in the regulations. Yeah, but ideally what the documents you need to provide during your application is proof of your deposit. So previously, the deposit was set at 10% of the value of the unit. However, this has now, well, the regulations are not out, but there's no provision for that. So the 10% is not mandatory unless, again, it's provided for. So now the regulations will tell us what the deposit will be. So then you'll also need to attach your national ID, and if you're a company, then your certificate of incorporation, as well as your KRA PIN and your TCC. Again, in line with the agenda of the government, the priority will be given to marginalized persons. So basically youth, women, and people with disability. So basically all the funds that were collected when the Affordable Housing Levy was covered under the Act will be deemed to have been commenced under the Act. So the Act covers everything, the Affordable Housing Levy, even before the Act actually came into force. So the transitional provisions provide for this. So anything that was done before the Act came into place under the provisions of the Finance Act are now wrapped up and deemed to have been commenced under the Act. So what are the key concerns? So the main one is the definition of what your gross salary or what gross income is. So there is no definition in the Act, which again raises questions of what element is being subjected to the Affordable Housing Levy. This was also the case under the introduction in the Finance Act. There was no definition. However, carriers, the collecting body, went ahead to define what the gross monthly salary was. So what they said, well, the notice basically, which we will project after this slide, basically provided for your monthly gross salary to include regular allowances. So these are things that will be there, you'll be provided on a month-to-month case. So housing, traveling, commuter allowances, basic regular cash payments. So if it's appearing in your payslip every month, it will be covered as to include your gross monthly salary, but it excluded non-cash payments and payments that were not regular. So things like leave allowance, bonuses, gratuity, pension, severance pay, and terminal dues. This will ideally occur not every month. So anything that is occurring, which is not regular in its occurrence, would have been excluded. However, we are yet to see whether further guidance will be provided, whether in the regulations, again, by the KRA, so that people are aware of what exactly constitutes gross salary as well as gross income for the non-salaried people. Okay, I think that will be it on the Affordable Housing Levy, unless there are any questions.
So thank you, Liz, for the session on affordable housing. So far, I can see the questions on the chat. So I'll address two questions. The first question is, could you kindly clarify how the unsalaried individuals go about paying for housing levy?
Unfortunately, this has not been clarified. So I'm assuming this will be covered in the regulations once the regulations are gazetted.
Okay, so the next one is for voluntary savings, what is the interest rate to be used for accrual?
Sorry?
For voluntary savings, what is the interest rate to be used for accrual?
Again, the government will provide for what the interest rate will be. I haven't seen this yet, but again, it will probably be in the regulations.
Yeah. So that is the two questions from. For the other questions, I'll take them after we have the next session. So for this session, I was only taking two. Maybe just a clarity on for voluntary savings. The interest rate will be prescribed in the regulations. It's not yet in the Act. Yes. So ideally, that will be what will happen. So we'll proceed to the next session, which will be presented by Maureen Nyatichi. That is the implementation of the NSSF. In case of any questions, I'll address them after the session. So Maureen Nyatichi, welcome.
Good morning, everyone. Sorry about that. Welcome to our virtual webinar training today. My name, as introduced, is Maureen Nyatichi from the Legal Department, Taxpayers Africa Consulting. I will be discussing the NSSF contributions and the recent developments on the same. You'll note that I'll keep referring to the old Act and the new Act. So as not to get confused, please keep in mind that the old Act is the NSSF Act number 28 of 1965. The new Act is the NSSF Act 2013. So now, under the old Act, we go to the contributions under the old Act. So under the old Act, the contributions were deducted at a fixed rate of a flat rate of 400 shillings, where the employee would deduct, the employee's salary will be deducted 200 shillings. Then the employer would match the same and add a 200 shillings on that. This means that the employee's NSSF account would have 400 shillings. That was the flat rate used for all the deductions. So now, the new Act 2013, which was enacted in December and set to commence in January, came with several changes. Some of them are changes on these rates, changes on some obligations. However, you'll note that implementations of this was stalled due to a court order and the several petitions that were filed. I will talk about that in a bit. But for now, I'll mention a few of the changes that were introduced under this act. So, as I mentioned, there was the changes on the rates, but there was also an introduction of a two-tier system. Previously, it was just one tier, but now with the enactment of the 2013 Act, it sought to introduce a two-tier system whereby contributions to the NSSF fund would be two-tiered, tier 1, tier 2. Contributions under tier 1 would have a different rate, contributions under tier 2 would have a different rate. Another change that it introduced was a mandatory obligation for any employer who's employed one or more persons under a contract of service. They had to register with the fund and ensure that their employees have registered with the fund. There was also an obligation to remit to the fund on the 9th of every month, failure to which there'd be penalties on the employer. So now let's go back to the rates, which has been a matter of contention in court. So now, the new act sought to increase the rates. As I've mentioned, the old act set rates at 400, which was 200 on the employee, 200 on the employer, matching the employee's contribution. This new act now revised this rate from the 400 to 840 for tier 1 and 12% for tier 2. So 840 meant that the employee contributed 420, the employer contributed 420 for the tier 1. Tier 2, 6% on the employee, 6% on the employer. Also, another change you'll note is that now tier 1 was mandatory in this new act. And tier 2 applies to the upper earning limits. We'll also talk about the limits. So these rates were applied on a graduated scale, which meant now that higher earning employees would contribute more to the fund. Also, the earning limits were set for annual reviews. So previously, the earning limit was set on the lower earning limit of 15,000 Kenyan shillings. But now with this new act, there was the lower earning limit is different for every year. So the review for this earning limit starts after the commencement, on the anniversary of the commencement of the act. So after the first year of operation of this act, the limits would be revised and would apply to the first year, second year, third year, all the way to the fourth, to the fifth year. What this means, if we use 36,000 as the upper earning limit, so for the first year, the upper earning limit would be half of that, so it will be 18,000. For the second year, it will be 1 times that, so it will be 36,000. Second year after the commencement of the act, it will be 72,000. On the third year, that will be 72,000. Fourth year will be 108,000. The limits will be revised as per the statistics of the Kenya National Bureau of Statistics analysis. As I mentioned earlier, now that we know the old rates and the new rates, implementation of this act now was stalled due to the petitions. So the first petition was filed in several towns by different petitioners, but they were all consolidated and determined at the Employment and Labor Relations Court in Nairobi, which declared this act unconstitutional for various reasons, including the mandatory obligation for the employer. After the decision of the Employment and Labor Relations Court, the NSSF board, together with other respondents, filed an appeal, with other appealants, filed an appeal at the Court of Appeal, which restricted its determination on the matter of jurisdiction, whether the Employment and Labor Relations Court had jurisdiction to determine the petitions that were filed before it. So the Court of Appeal determined that the Employment and Labor Relations Court had no jurisdiction. The impact of this is that it set aside the Employment and Labor Relations judgment on unconstitutionality, and now the new rates were implemented. NSSF issued several notices and started implementing it from February 2023, all the way to February 2024, when now the appeal that was filed at the Supreme Court was determined, and the Supreme Court ruled that the Court of Appeal was wrong in holding that the Employment and Labor Relations Court had no jurisdiction. So they sent the matter back for a determination at the Court of Appeal. So now that's where the dilemma comes in. What rates are to be applied? Is it the old rate as per the judgment of the Employment and Labor Relations Court, which set aside the implementation of this act? Or is it the new rates relying on the Court of Appeals holding? There are two different schools of thought. One school of thought, which is championed by the NSSF, is that the Supreme Court did not affect the Court of Appeals holdings. So the Court of Appeal holdings that the Employment and Labor Relations Court lacked jurisdiction were not done away with, were not set aside. So that means the position as per NSSF and other schools of, and other people who prescribe to that school of thought is that the act is still in force. But however, legally, if you delve into what is the status, if the Supreme Court set aside the judgment of the Court of Appeal and declared it wrong for holding that the Employment and Labor Relations Court did not have jurisdiction, then that means that the Labor and Relations Court had jurisdiction. That means the Labor and Relations Court judgment of unconstitutionality is what remains. So then that means the old rates are the ones that apply. You can read more on our analysis of that judgment in our website. So what does that mean now to an employer and an employee? Do you prescribe to the old rates? Do you prescribe to the new rates? Our position is that the status of the employment and the status of the NSSF Act is as per the holdings of the Employment and Labor Relations Court. It cannot be enforced. The new rates cannot be enforced. The deductions will be based at the fixed rate of 400 as per the old Act, that is the Act of 1965. So, unless there's a question.
Good. Thank you so much, Maureen. As per the chat, I can only see questions relating to the affordable housing. So in case of any question.
Diana, we can't hear you.
So thank you so much, Maureen. I just wanted to indicate that so far I can only see questions relating to the affordable housing, which will be addressed at the end of the session. In case of questions relating to the NSSF, I will raise them to you. For the people who have raised their hand, I acknowledge the same, and I will have your questions addressed at the end of the session. So in the meantime, so as to save on time and to have more time for question and answer. Okay, so there's one question from Bernadette. Bernadette. Bernadette is asking, does it mean it's legal to deduct NSSF with the new rates?
Well, you can't really term it as illegal, but then it wouldn't make sense to rely on the new rates, and there is no law that supports the new rates. So really, it will be just unlawful to rely on a law that was declared unconstitutional. However, the substantive appeal at the Court of Appeal is still yet to be determined. So the status of whether this act is constitutional or not, at the moment it's unconstitutional at the Employment and Labor Relations Court judgment. But in case of any developments from the Court of Appeal, we are yet to see whether it will affect that status.
The next one is Zacchaeus. Zacchaeus is asking, so this month we are not limiting the NSSF. We are not, I think, should be limiting the NSSF as per the new act.
If we go with the second school of thought, which is that the Employment and Labor Relations judgment is what is the status quo on the act, then this month the deductions will be as per the old rates. which is the 400 flat rate.
Maybe I can add also on that point. So basically what that means is the NSSF basically provided a guideline. So even if you try to log in into the system and try to make payment, it will only limit you to the existing rates as per now. So as much as there's the school of thought that the NSSF Act 2013 is unconstitutional, the NSSF has a position, and based on that position, it has actually limited you in terms of how you can maneuver through your declarations. So basically your declarations and payment are on the system. So there's no way you can maneuver through that. So ideally what you should be reporting is per what is on the NSSF notice that was shared. So let me go to the next one. What do you advise employees to deduct using the new rates or old rates? So I think I've addressed, that has been addressed based on Zaki's question. So for the next questions, that is for Eunice, Eunice going forward. I think for also Zaki's, the NSSF portal has the option of new rates. I think that's what has been addressed. So for the other questions, I'll let them be handled at the end of the webinar. So next we'll proceed to the SHIF Act. So for SHIF Act, the same will be analyzed or be guided by Kate and Brenda. Kate will commence. So Kate and Jue, you can take the floor. Thank you.
Thank you, Dana. So for the SHIF Act and the SHIF, which is the Social Health Insurance Fund, this is basically an insurance scheme that pulls contributions from members to allow them to access public health services. So the SHIF, or I may refer to it as the SHIF Act, but it's really the Social Health Insurance Act, was assented to on 19th of October 2023. And maybe we could move to the next slide. Yeah, it was assented to on 19th of October 2023 and commenced in November 2023. But the regulations were only passed this year on 8th of March 2024, whereby the regulations are the ones that actually practically operationalize the provisions in the Act. So you'll notice the Act provides for definitions, it provides for who a member is, who a contributor is, who a beneficiary is. It provides for various funds, but the actual benefits of the scheme, the actual rate of contribution, the modalities of registration, all of those are captured in the regulations. And those regulations were only recently gazetted. So the Social Health Insurance Act, it repeals the National Health Insurance Fund Act 1998, which is what we all know for NHIF. So the Social Health Insurance Act was passed together with 3 other related laws. It was passed with the Primary Healthcare Act, the Digital Health Act, and the Facilities Improvement Financing Act. All of these were passed last year. Basically, the social health insurance is supposed to be a step towards realizing the right to attainable and high quality healthcare for everyone, which is provided for in Article 43 of the Constitution. So the Act also establishes the authority, the Social Health Authority, to replace the NHIF authority. It establishes 3 funds, which is the Social Health Insurance Fund, the Primary Healthcare Fund, and the Emergency Chronic and Critical Illness Fund, which I believe my colleague will explain in depth in the following slides, because the contributions basically inform some of the specifications of those funds. So basically when SHIF, while it was introduced last year, there was some dispute and some controversy around it. So in the case of Cabinet Secretary, Ministry of Health versus Aura and 13 others, this is the Court of Appeal case. Basically, the case originated at the High Court. The petitioner moved the court to saying basically that the 3 acts were unconstitutional, challenging all 3 acts, basically arguing that there was not effective public participation, challenging some of the provisions there, including the fact that the Act requires registration, it requires up-to-date contributions, it requires contributors and beneficiaries to be identified digitally to be able to access public health services. So those were some of the grounds of the petition. And the High Court basically issued orders that restrained the Cabinet Secretary and the agents from implementing all of the 3 acts. So the CS appealed to the Court of Appeal against those orders, basically seeking those orders to be lifted or stayed pending the appeal of the case. So the Court of Appeal determined in favor of the Cabinet Secretary, basically lifting the conservatory orders but suspending specific provisions. So the provisions that are still pending determination are specific to registration, which is section 26.5, which basically requires a person to be registered and to have made up-to-date contributions to be able to access public health services. And also in respect to contribution, that's section 27.4 and section 47.3, which requires persons to be uniquely identified. So this case practically prompted the CS to push the regulations, which have since been gazetted, as we've seen. And so now the provisions are in force, and registration, as we'll see, is supposed to commence and should be done by not later than 30th of June of this year. So basically, as we said, registration is a pre-requirement. It's a precondition to be able to access healthcare services from public facilities. And there's the initial registration of members. So even if you are under NHIF, all members are required to register afresh. And the regulations have put in the designated points of registration, which is the branches that will be established under SHIF and the Huduma centers and any other places that may be designated by the CS. So the Act provides for persons who are required to register as members under Section 26, and this is basically every Kenyan is required to be registered as a member of SHIF. Non-Kenyans who are ordinarily resident in Kenya are eligible, so that's voluntary for registration as members, but any Kenyan who intends to enter and remain in Kenya for a period of less than 12 months is required to retain a travel health insurance cover. So as was, and children born after the commencement of the SHIF or of the Social Health Insurance Act will be registered at birth under this act. So registration will continue continuously as was with NHIF. And and also in the event that you need to amend perhaps the list of beneficiaries, the regulations provide for the same, so it's also possible to amend. The prescribed form for registration is provided for in the second schedule, and you're required to fill in the form to provide a copy of your ID. The regulations in the Act also provide for biometric data, so there's also digitization of data, and you'll remember the Act goes together with the Digital Health Act and the Data Protection Act, so data will be managed in accordance with those acts. So yes, basically. So the main point to note is that registration is a pre-requirement for accessing public health services, and that initial registration should be done by not later than 30th of June of 2024. So for the next provisions on contribution and the funds as well as the regulations, my colleague Brenda will be taking us through the same.
Brenda, kindly unmute. Brenda Mtola.
Okay, sorry about that. So I'll proceed from where my colleague Kate left off. So we're just proceeding with the SHIF regulations. So basically, the SHIF regulations, their object is to give effect to the provisions of the Act, the Social Insurance Act. So basically, everything, how the Act is supposed to be enforced, implemented, all the actions are as provided in the regulations. So as my colleague Kate has mentioned, registration doesn't matter if you are under NHIF or registered in other form. Everyone is required to register afresh for SHIF, and the contributions will start by 1st of July 2024. So in terms of the contributions, the people who are liable to contribute is every Kenyan household will contribute. The national government and county government will also step in to contribute in cases where maybe some houses do not have the capacity. The employer also has the obligation to contribute, and also non-Kenyan residents who are in Kenya for a period of more than 12 months will have to contribute. So in terms of the breakdown of the contribution, so as I mentioned that the SHIF regulations, they're the ones that provide a breakdown of how the contribution is to happen. So we have 5 aspects of the contribution. The first one is a household that has salaried employment. So if a household has somebody who is employed, they will contribute a monthly deduction of 2.75% of the gross salary. And this has been capped to a minimum of 300 per month. So whatever you contribute, that 2.75% of the gross salary, the minimum you can contribute is 300 shillings. Now we have other households whose income is not derived from salaried employment. So for salaried employment, it's really easy to tell how much someone is earning and how you can quantify that percentage so that you can get the 2.75%. Actually, it's a very quick win. But now we have households whose income is not derived from salaried employment. So the regulations provides a method called means testing, whereby you can be able to tell the salary, the gross salary, the gross income of such a household. So after determination of that, of the income, 2.75% of that amount is contributed. This one, you realize it is an annual contribution. The one for salaried employment was a monthly statutory deduction. Now, the third one is for households in need of financial assistance. So for households in need of financial assistance, also the means testing method is used to determine. You can't just assume that, sorry, just give me a minute to change.
Okay, so I'll proceed with where we were at the contributions. We've covered the first people to contribute, which is the salaried employment.
household, which I've clarified that is 2.75% of the gross salary. The second one, we have the second contributor and the third contributor. So as I have mentioned, there is a method called means testing, which is outlined in the regulations. So for the means testing, it is whereby the authority will assess how much the household can contribute. So in case of a household that, yes, they can be able to afford to pay for the income. However, since it is not consistent like salaried employment, the means testing will be able to determine that income, and then they will contribute 2.75%. Also notice that in this case, it is capped to a minimum of 300. So even if your income is not from salaried employment, per month you have to ensure that whatever you contribute annually is not less than 300. Now we have the other case of households that need financial assistance. So in these households, they do not have the capacity. So also this is determined by the means testing. So in this case, the government, the national government and the county assemblies will be the contributors for these households. Then we also have SHIF covering persons under lawful custody. This means people who are arrested, people who are in remand and the likes. So in such a case, the ministry in charge of the lawful custody will make the contribution. Yeah, so basically that is it in terms of the contribution. I'll move on to the next part. Whereby now the term beneficiary has been used in the regulation. So I think it's very important for you to understand who a beneficiary is. So the first definition is the beneficiary is the contributor. As an individual, you as a person who is making the contribution to SHIF, you are a contributor. So under the contributor, there are some specific people who are beneficiaries who can enjoy from the contribution of that contributor. The first one is any person who has not attained the age of 21 years and they have no income of their own and they're living with the contributor. This points out to the child aspect because ideally you're supposed to register for SHIF when you turn 18, but since they concern themselves with the situation of the people, so they've pushed it to 21 years. So if your child is has not attained 21 years, they're living with you, you're still their contributor, so they're a beneficiary. And then there is also another aspect whereby they have increased the rate to the year to 25 years, but in this case, you have to be undergoing full-time course. So if you're a student undergoing full-time education, you are a beneficiary and the contributor you can benefit from the contributions. Now, the other aspect, so technically this means anybody above the age of 25 years, you're supposed to make your own contribution to SHIF. Now, the other beneficiary will be any person with disability, and you're living with the contributor, you can benefit from their contributions, and also for a spouse of the contributor. Now, my colleague Kate has mentioned about registration. So when you're registering in the prescribed form under the regulations, under the SHIF regulations, this will be shared after the presentation. They are the prescribed forms for registration. So you can also declare your beneficiaries at that point. Yeah, so in the regulations, it provides that after you have presented your applications with everything, within 14 days after the registration, the authority will communicate to you and issue the social health number. Now, in terms of penalties, the penalties are really high. So you get that if you fail to contribute and you're ideally falling within the brackets of people who are supposed to contribute, you will pay a penalty equal to 2% of the amount due for contributions. The regulations further provides that you will be notified if at all you haven't paid and you have a penalty to pay, you will be notified. You can also request for a statement to see how your account runs, which will populate everything for you. Now, the next part, I'll go to the funds and benefits under the Act. So as we've, through the discussions, you've noticed that we've mentioned 3 funds, the Primary Healthcare Fund, the Social Insurance Fund, and the Emergency Chronic and Critical Illness Fund. Now, just to note, because this one goes hand just to compare with what NHIF had. So the idea of SHIF is to provide for everyone. So ideally, the thing was that NHIF was only targeting the salaried people because it's easy, it's a quick win because you can just have the obligation on the employer, it's a statutory deduction. And then the NHIF Act also just for registration provided for anybody who is above 18, you can register. So no more, no less. But when you get to SHIF, you realize that almost everyone, most people have been, you fall into one bracket or not. Even if you can't contribute, there is that one of financial houses that have financial problems. So in this case, upon means testing identification, and the government realizes that you actually cannot, you cannot pay for yourself. The government contributes for you so that at least you can access even the primary health care facilities. So that is the idea. So under NHIF, we only had the NHIF fund, but here in the Social Insurance Act, it comes with 3 funds. So the first one is the primary healthcare fund. So basically, this is the first level where it's available to everyone for preventive purposes, and the likes. So for this one, you can access level 2 primary health facilities, level 3, or a level 4 primary health care facilities. But you have to realize that all these facilities, they have to be empaneled by the authority. Even for SHIF, these health facilities have to apply to be licensed by the authorities. Yeah, so we will have the primary health facilities that have been empaneled for that purpose, even for the social health insurance and the emergency. So basically for primary, their object is just to process the primary healthcare services from the primary health facilities at least at the moment where at the point where it's open to the society to access the treatment. Now we have the next one as the SHIF, which is the one that we are discussing right now. So for SHIF, it's important to note that it requires mandatory registration. It's not a choice. It is not a choice. It is mandatory. So every Kenyan resident, as mentioned by my colleague Kate, falling into those brackets, you're supposed to register. So this fund, basically all the contributions for this purpose are in this fund. It also purchases healthcare services now from those licensed health facilities as referred from primary health facilities. You realize that you have to be referred to the next level. So for the SHIF, you use the level 4, 5, and 6 health facilities. Now we have the other stage, the other fund for emergency, chronic, and critical illness. Now this one covers emergencies and critical illnesses. Now for this one, if you are under SHIF and you have depleted your costs, you now proceed now to this fund, which will facilitate now your costs and everything. Yeah, we can proceed to the next slide. Basically, this is just a highlight of the SHIF regulations. So basically, as I've mentioned, they're just for implementing everything that is in the Act, implementing the primary healthcare fund, social insurance fund, and the emergency, chronic, and illness fund. It also provides guidelines, especially for the health facilities, of how you can be contracted and be part of that list of health facilities which are under this SHIF. It also provides for the benefits, yeah, and all other information that you may need to facilitate any process under the Act. Yes. So with the gazettement of the regulation, it is now clear. You know, there was a speculations that contributions will start in March. People were not certain, but the regulations clearly point out that the contributions will start on the 1st of July, 2024. Yes, I think I have highlighted most of in summary of what is in the regulations. I'll be open to any questions in case of any clarifications. But just as I wind up, maybe I can mention about employers' obligations. As you've seen, for the people who are liable to make the contribution, employers are liable to deduct from their salaried contributors and submit to the authority. In case of any change, let's say termination of employees, you're supposed to alert the authority so that they are aware that that person is no longer working for you. Once you alert them, the obligation for you to remit the deduction now lapses. Yeah. So for registration, employers also, even as everybody else is registering, you're supposed to register with the authority. Basically, just have your a copy of a certificate of registration or incorporation and a copy of your PIN certificate, so that now you can start remitting for your employees to SHIF to the authority. Yes, I believe that I covered most of it. Yeah, other issues that maybe we can look out for. We realized that when we had NHIF, we used to get a relief for NHIF. However, this has not really been clarified in the regulations or act, but as we proceed, I believe we'll get more guidelines on it. Yes. So Diana, I'll hand it over to you.
Okay, thank you so much, Brenda. For these, I'll take 2 questions, then we can have now a general question and answer. So for all those who have raised their hands, you'll also have an opportunity. So the first question is, will all employers have to register again to SHIF, or will the NHIF registration apply? Brenda, did you hear me? Will all employers have to register again for SHIF, or will the NHIF registration apply? Okay, as we wait for Brenda, I can start handling the affordable housing. The affordable housing levy. So I'll for those that for the ones that I had handled, I'll let that go. So I'll proceed to the next one. That is Elizabeth will be handling them. If this is effective, if 19th March 2024 salaries. Okay, if this is effective 19th March, salaries accrue from 1st of the month, last day of the month. Does this mean then that the amount applicable for deduction is from 19th to 31st March? So ideally, the question is, at what point do you start deducting? From 19th to 31st or from 1st to 31st? Elizabeth.
The assumption is correct. You could argue that it will apply from 19th, basically, since it is when the act came into force. But again, you need to remember that, again, it's on accrual. So you'll say the gross salary started to accrue at the beginning of the month. So as much as you would want to say from the 19th, the accrual basis might disqualify you. Again, then for this reason, we recommend applying it to your full March salary.
I hope that is clear. The next one is salary increment arrears payment deductible in the affordable housing levy.
So I'm assuming that this is arrears from periods when the housing levy was not in force. So if this is the case, then this income was accrued before the act came into place. So for that reason, again, this would be treated as, this would not form part of your gross salary for that month. I hope this is clear.
Okay.
Yeah. So anything that you accrued before the act came into force will not be included as part of your housing levy gross monthly salary.
Next is clarify on the 9,000 monthly limits.
So I'm assuming this is on the relief. So ideally, if you let's use an example. Assuming your salary, by salary, we just saying salary because most people are employed, but in general, just assume it's the gross. So assuming your salary is 100,000 in that month, so it will be the 100,000 times 1.5 to get your affordable housing levy. So that should be around 1,500. So the relief is on your contribution. So your contribution is the 1,500 basically. So it's 15% of the 1,500 is what your relief is. So if you're a high income earner and your relief was more than and the relief basically is more than 9,000, then you'll cap it at 9,000. In the whole year, it will be 108 for the whole year. But for that month, your relief you can't be allowed a relief of more than the 9,000. Same as for your insurance, personal relief, there's usually a cap. Think of it the same way. I'd seen someone in the comments doing the relief to be the housing levy minus the relief. Unfortunately, this is incorrect. So your relief is on your contribution, then you'll deduct it from your final pay payable. The same way you do with your housing, personal relief, insurance relief. So the affordable housing relief will be the same from your pay, not from what you're contributing.
So Jennifer is asking, clarify on the 15% relief of housing levy. I believe that has been responded to. Fiona is also asking, could you clarify on 15% relief calculation? Also, if the relief is charged in pay or on the housing levy? I think that has been clarified. So ideally, the questions that I'm seeing are on the relief, housing relief. So unless anyone has a question on the chat and they have raised their hand, I think I can give you an opportunity. So we can start with Venu. Venu, you have your hand raised up. So Miss Oyile. Miss Oyile, you have the opportunity to ask your question. Okay, I can proceed to Joyce.
Can I be heard? I was having some challenges.
Yeah, we can hear you. You can proceed.
Can you hear me?
Yeah, we can hear you, Miss Oyila.
Is better? Yes, you can hear me.
Yeah, we can hear you.
Okay, I'll trust that you can hear me. I have two questions. Number one is the clarification that has been made on the tax relief. For me, I got confused with that clarification. If she does not mind repeating. And the second one is on the SHIF, the effective date being 1st July 2024 for the payment of contributions. I'd like her to share what she understands by that. Does that mean that presently we can we of course are not making any contributions towards the SHIF? And number two, does it mean that for now we don't get to pay in HIF and we're not paying SHIF until 1st July? I hope you've had my questions.
Okay, thank you, Ms. Oyela. I'll give the opportunity to Elizabeth to handle on the affordable housing. First.
Okay. So basically, if you're contributing to the affordable housing levy at 1.5% of your gross income, you will be allowed a relief of 15% of your contribution. So your contribution is the affordable housing levy amount that has been, assuming you're employed, that has been deducted. So again, we go back to the example I'd given. So your gross salary, in this case, is 100,000. So to find what your contribution is, I'll do the 100 times 1.5%. Then I get what your affordable housing contribution is. Just your portion, when this does not include the matching element by the employer. So your portion of the contribution is 1,500. So 1,500 is your contribution. So the law now grants you a relief of 15% of that. So 15% of the 1,500, this should be around 225 shillings. So that is your relief. So ideally, since it's below the limit, you'll claim the whole 225. But assuming you are a high income earner, and this was more, so this would basically be now for the people who are not in employment. So even in employment and you have a very high salary. So assuming you've done your contribution, so let's just use an example of someone who has more. So assuming you're earning your gross earnings for that month, your gross income is 10 million. So your affordable housing levy would be 150,000. Then 15% of the 150,000 is 22,000. So of the 22, you can't claim the whole 22,500. You'll only claim a relief of 9,000. So anything above that, you will not claim. I hope this is clear. Miss, I don't know, just let me know if this is clear or if I should explain further.
Yes, I hear you. So at what point would I be claiming this relief? Can I pay a claim?
Yeah, so the relief you'll claim on contribution, because what the act says is if you can prove that you've contributed. So ideally, if I'm able to prove this month, then I will claim the relief this month. But I've looked at the pay return, because this is now the one I can look at. They've still not included it. So again, so if it's not included, then you'll just claim it at the end of the month. But ideally, so we don't end up in refunds, it should be at the point of, at the payroll level. Because again, if you don't claim it monthly, you'll have a small refund per se at the end of the year, which is unnecessary, to be honest.
Thank you.
Okay, thank you. I can proceed. Chief Accountant. I can just see it's written Chief Accountant. You have a question? Okay, I can proceed to the questions on, unless anybody else has a question on affordable housing, I want to proceed to the NSSF. Okay. So for NSSF, the first question is, what do you advise employers to deduct using, would you advise the employers to deduct using the new rates or the old rates? Maureen?
So technically, from from a practical perspective, there's a lack of certainty on what to do next on the rates issue. From the two schools of thought, NSSF as the statutory body is of the first school of thought that the judgment did not affect the status of the act is enforceable, which from the second school of thought, from someone who supports the second school of thought, is an incorrect interpretation of the act in a bid to ensure continued remittance of the contribution. So ideally, since it's the statutory body, no one has challenged the issue that they noticed that they issued, they went ahead and enforced their interpretation on their portal, which a majority of participants also noticed that. So since remittance is on that portal, ideally we will just remit as per what's on their portal. I hope that answers it.
Okay, so the next question is what happens to those who had opted out under the based on the NSSF Act 2013? So there are those employers who opted out of the NSSF and went through the private scheme for themselves. So what is the implication of that?
So whether that's valid or not, it's still valid. Since let's go as per what the statutory body is implementing. If it's implementing the new rates as per the new act, the 2013 act, from their interpretation of the Supreme Court's judgment, then it doesn't affect the employers who opted out and decided to remit the contributions to their private pension scheme of choice.
And maybe just to add on that, if you notice, is that the NSSF actually, the authority is the one that actually was giving approval for people to opt out. So if you opted out, you are still covered because you have that legitimate expectation by the NSSF actually giving you the authority to opt out. So you cannot say it's out, it's null and void. I think the fact that you actually got the approval of the NSSF to opt out, which is actually a requirement of the NSSF Act 2013, then you are covered. So our next question is, but the NSSF portal, I think this has been addressed, the fact that the NSSF portal has only catered for new rates. So what's the way forward? Pay new rates as NSSF have not provided a system to pay. So yeah, pay the new rates as is, which has been clarified by Maureen. So next is the SHIF. Thank you, Maureen. I'll proceed to the SHIF Act. The SHIF Act basically is, please share as a link or copy of the Gazette notice gazetting the SHIF regulation. So this will be shared with you after the session. Next is, so if I register and contribute through my employment, should I also register my dependents? We can have Kate respond to that.
Yeah, so basically for registration, you're required to give you're required to give the information, the list of your beneficiaries, and you'll notice that the biometric data of those beneficiaries is also required. So you will be required to register your beneficiaries. If that answers that question, you'll be required to register your beneficiaries. And I noticed, if I could just, Diana, tie it with the question, which is where to register. The registration points are the Huduma centers, the branches of SHIF, which we anticipate will be established, and any other place that will be designated by the Social Health Authority. Yeah.
So the next question is, what if a person is retrenched and unable to secure employment thereafter? As well, you are above 25 years and have never been able to secure employment and are fully dependent on family.
So to address that question, ideally, if you look at the list of contributors, everybody above the age of 25 years, they're supposed to register and make their contributions on their own, unless if you have any physical challenges and you're wholly depending on the contributor. So it's also important to notice that the minimum contribution is 300 shillings. So if at all you're not falling into those categories, remember in our contributors, we had a list whereby we had households who had financial, who cannot contribute, who have financial challenges to contribute. In such a case, you may fall there. But for you to fall there, as I had mentioned earlier, we have the means testing to establish if you actually fall under the people who cannot, who do not have any finances to make the contribution. So in such a case, the national government will contribute for you. But as I have said, it is not automatic. You have to undergo the means testing to confirm that you actually cannot make the contributions and all the features of, and you fall in the brackets of people who are actually supposed to contribute. I hope I have answered your question.
Next is, could you clarify that point of depleting the SHIF and accessing the emergency funds under the SHIF Act?
Okay, so we have the SHIF. So under the SHIF, you are able to access health facilities as have been referred by the Primary Healthcare Fund. So when you get to SHIF, SHIF can handle your chronic illnesses. So you'll realize the third fund was emergency chronic illness and fund. So for that fund, it mainly deals with emergency. But now you'll realize under the fund, it has made two distinctions. The first one is to defray or to cater when you have depleted your cost under SHIF for chronic illnesses. So chronic illnesses can be treated under SHIF. But now when you have depleted all your costs, you're then moved to this fund, the emergency fund. But the main purpose of the emergency fund is to treat emergency illnesses. So when you're dealing with chronic illnesses, which can be handled under the SHIF, and it is depleted, now you're moved to now this other fund.
And maybe just to clarify, for the emergency and the primary, those are contributions by the government. So ideally, once you deplete the SHIF, you move now to the emergency and chronic section, which is now a contribution by the government, so as to form now what you have, the three funds. Next is, will there be an equivalent tax relief on SHIF?
For that question, I had addressed it earlier in items that we are seeking clarifications. It is for NHIF, of course, we were able to enjoy the relief, but from the regulations and the Act, we have not seen any communications on the same, but we believe that in the coming future, because those are some of the queries that are being raised right now, because if you're replacing NHIF and I was getting relief, why shouldn't it be the same as SHIF? So we are waiting also for clearer guidelines on the same, even as people are starting to register.
And next is, will all employers have to register again for SHIF, or will the NHIF registration apply?
So I'll give my colleague Kate to address that.
Yes, so you're required to register afresh as the employer. There's a prescribed form 5 in the first schedule. The employer is required to register afresh, basically under SHIF. Everyone is required to register afresh under SHIF.
So the next one is, for SHIF, what is the implication of this contribution versus private medical premiums that are already paid or have been paid for the full year 2024?
So to address that question, maybe I'll start off by highlighting that SHIF is mandatory. So for SHIF, in the schedules provided in the regulations, you'll be able to see all the benefits that you can get from this mandatory request. So for example, you can get inpatient, outpatient, the emergency treatment. So for you to use other funds, it is not illegal, or it is not, it is a matter of preference. You can have additional medical premiums from other insurance, health, and the likes. But for SHIF, you have to note that it is a mandatory requirement. It has its specific benefits outlined in the regulations. So you can, it is not illegal for you to have other private funds and the likes. That's okay. That's a different arrangement that you have. But for SHIF, it has its own benefits in the packages, in the schedules, which we will share with you all after this presentation, so that you can have a look. So what I'm trying to say is that you're not limited, because you're not limited from other funds because you're using SHIF. SHIF is mandatory for everyone, and it has its benefits. But then you can also have your own preferences. That is after you have registered with SHIF. Yeah.
So the next one is, what is the effective date of deduction of SHIF?
So to address this was one of the questions that was bringing a lot of speculations before the gazettement of the regulations. But in the regulation, section 6, it provides that contributions will start on the 1st of July 2024. So ideally, we have been given a window up to 30th of June 2024 to make sure we've all registered. Even as my colleague has mentioned, you can register at Huduma centers, any branches of the authorities, and they also listed that they will communicate more areas or more ways where you can register, and they will also provide mobile registration points for people who ideally cannot get to those centers. So yeah, so ideally by 30th June, 2024, everybody should have registered, and the contributions to begin on 1st of July 2024.
Next is, just a minute, does SHIF phase out NHIF?
Sorry?
Will SHIF phase out NHIF?
Yes. So you'll realize even in the regulations, NHIF has been referred to as the repealed act. So ideally, SHIF has already phased out NHIF. And the communication as per the regulations is that every person who had registered under NHIF is required to register under SHIF. If you had made any contributions under NHIF, the same will be transferred to the authority, to now the SHIF authority. So that's why it is for everyone to register afresh with the SHIF. Everything to do with NHIF has been phased out with the Social Insurance Act, and also the regulations for NHIF have been repealed by the Social Health Insurance regulations.
So next is, I think this is a comment on relief. This is will likely be addressed in the finance legislation, I believe Finance Act 2024, similar to what we have under the NHIF, which was introduced under the Finance Act 2021. So I believe this is a comment. The next one is, how are employers contributing the SHIF?
So employers, basically, they have the obligation to deduct the SHIF contributions. That's why they have, in our presentation, we had highlighted employers' obligations. You realize that in the contributions, we have salaried households and the likes. So if you have employed anyone as an employer, you're required to make the deduction and remit it to the authority. So ideally, every employer has that obligation. In case you terminate any employee, you're also required to communicate to the authority. So basically, the role of the employer is now that deducting that contribution, the 2.75% of the gross salary, and remitting it to the authority. That's why they are required to register. There is a prescribed form in the regulations for all employers to register.
So basically what's coming out is the employer deducts. In this case, the employee contributes. So the next question, I'll give to Harry. I've seen Harry, you've raised your hand. You have the opportunity to ask your question. Okay, as we wait for Harry, I can ask, there's a question here. The question basically, is the relief of affordable housing confirmed? Elizabeth?
Yes, the relief has been confirmed. So initially, when the Act came into effect, it was just the charging section, which was 4 and 5. But the rest of the Act was gazetted, and so it's in force on 22nd March. So everything in the Act is in force. So the relief as well as the affordable housing are both in effect.
Okay, fine. So I cannot see any further questions on the chat. If anyone has a question, you have the opportunity to state your question right now. The same will be responded. I can see Vino has raised her hand, or his hand. Anyone on the chat is allowed to actually comment, state, or ask a question. So lastly is Edith. Edith, you have the opportunity. You can ask your question. Edith is so as we wait for Edith, there's a question that has just come in. Could you kindly please revisit the exemption under the Affordable Housing Act? I think that's on Elizabeth. Elizabeth?
So the Act provides for where an employer matches. The first one is, I think that is the one maybe you're asking. So where the employer matches the affordable housing levy for their staff, they will not be required to account for the affordable housing levy. So that's the first one. The second one is now where it's at the discretion of the CS National Treasury on advisement of the CS lands, basically. I hope this is clear. So if you're an employer and you're matching, you're not required to account for affordable housing levy for yourself.
Okay, so the people who wanted to ask questions, you have been unmuted. You have the opportunity to actually ask your questions. Thank you.
Thank you.
We can start.
So some of us, the payroll had already been done and we're not able to apply the.
Sorry, we can't hear you well.
I'm saying, now you can hear me.
Yeah, we can hear you, Edith.
Okay, thank you. So for us, it was still unclear whether we were supposed to apply the relief this month. But the speaker has said that the relief was applicable immediately. So what happens now for payroll in April?
Liz, I believe that is your question.
I've not quite caught the question, Dana. What was the question?
I'm asking, we were not able to apply the relief in March because we were not clear deadline for the housing levy. So is it something that now we can restrict the employees doing April their payroll?
I think they can still be able to put the whole amount at the end of the year while filing their individual returns, so it shouldn't be a problem. Yeah.
Okay, all right.
Next is you have, yeah, you can ask, you can proceed.
Okay, let me ask, under SHIF, do we have like a schedule that is guiding us on the level of services we can be able to get from these level 4 hospitals in terms of like the way our insurance works? If maybe you've paid premiums of 60,000, maybe you can enjoy 500 in terms of inpatient and 50,000 in terms of outpatient. Is there a schedule like that? Because when Kate was presenting, she mentioned something to do with the depletion of SHIF. Then one wonders what is this value that is being depleted? If maybe you can clarify. And I know this borders between us as Kenyan, just trying to understand the social health and the environment all together.
Okay, Kate or Brenda can address that.
So I'm not sure if I got the question quite clearly. There's something he mentioned on 60,000 payment. Maybe he can just.
So Kate, my question is, can you hear me? You can hear me?
Yes, I can hear you.
Well, there's this, and it's a follow-up question from the question that I had asked about depletion of the SHIF and then accessing the emergency fund. I don't know whether there's a schedule that is saying, while I'm paying this much money to SHIF, I'm being covered for this value of maybe like the way insurance work. You're covered for 500,000 within a year because you've paid X amount of premiums in terms of inpatient and outpatient. Is it working the same way, or is there a different arrangement altogether here?
Yeah, so it's not the way that you would have an insurance, a traditional insurance scheme, in the sense that basically the schedule in the regulations, it provides for services that are provided under the primary healthcare, which is just your essential outpatient, inpatient services, healthcare services. Then you have the services provided under the emergency, chronic and critical illness fund. So like cardiac arrest, shock, and the rest. But basically, if I've understood you, the services that you receive and the amount that is payable by the authority, it's not commensurate to your contribution. It's commensurate to the tariffs that the authority will set out as the amounts payable for a specific benefit. So in the Social Health Insurance Act, it provides that the CS will pay benefits based on tariffs. So those tariffs, it just means that if, for instance, they've set out for X-ray services or whatever, there's an amount that SHIF will cover for that specific service. So that's the amount that will be paid to the healthcare provider. I hope that answers your question. So the tariffs go hand in hand with the applicable to those, basically to those healthcare services.
Okay, thank you, Kate. I think you answered what I had imagined it would be.
Okay.
So the next person is, I don't know if there's chief accountant. Your hand has been raised.
Okay, sorry, let me ask a question. It's about SHIF. We said we can access level 4, 5, and 6. So does it mean that with the SHIF, we are confined to government hospitals? Sorry, I don't know whether I'm on the wrong.
Yeah, we can hear you. Kate, Brenda.
Okay.
Thank you. We've had your question. Kate or Brenda can respond to that.
Okay, so in responding to that question, I'll go back to the funds. We had the primary healthcare fund, and then we had the social insurance fund. So the primary one is whereby you can access level 2 and level 3 or a primary facility level 4. And then for SHIF, you access level 4, 5, and 6. So now, in terms of these levels, it is just the terms given to the health facilities. But however, there is this aspect of empanelment and contracting of health facilities. So in this regard, health facilities are contracted or they apply to be licensed by the authority. So the health facilities could be public or could be private. Okay, so you're not being limited to the public space only. So in terms, if you look in the guidelines, we have an aspect of, in the regulation, there is an aspect of empanelment of health facilities and contracting. So whichever health facilities you go to has to be licensed by the authority, and they license both public and private hospitals. So in terms of accessing primary health care, this is basically the preventive, curative, the first aspect before it gets that serious. The empaneled health facilities are recognized or referred to, the ones that are dealing for primary health care, level 2, level 3, or level 4 primary health care. It doesn't really mean that these are all public facilities, because both public and private hospitals have to apply to be empaneled as health facilities under the SHIF, under SHIF. So just to answer your question, it doesn't mean that you're limited to public hospitals only. I hope I have answered your question.
Thank you. Yes, you have. Thank you.
We have Joyce. Joyce. So unless there's any other person, for the remaining questions, let me just have a look at them, and then maybe we can see if we can handle them immediately, or we can just respond after this. So someone is asking, we are currently not able to use the NHIF in hospitals. Are you aware what is happening and how long it will take? And also the same person is saying, are we also going to select the outpatient facilities again? So that is for the SHIF team.
Maybe to answer that question, for the NHIF, what is currently happening? For that, probably, well, we are not that sure of it because it's a technological issue. Because I believe they sent out messages to all their clients, to all those people who've registered, mentioning technological issues. So for that, we'll just wait for guidelines, because at the moment, we don't have any clarity on that, although they have messaged almost everyone who has their contact, telling them of technological issues. Yeah. Then on the next question, on if we have to select outpatient facilities, it basically depends on the issue. See, for example, for primary, when you're accessing primary healthcare, it's mostly preventive or curative, like it's not that serious. So for that, it will technically most of the time be outpatient. Then if it moves to serious illnesses, then you go to SHIF, which can be either outpatient or inpatient, or emergency, which can be inpatient. So basically all these have been listed in the schedules to the regulations, and you can see. So basically you can access outpatient, you can access inpatient based on your condition.
Okay, so based on, thank you, Brenda, thank you, Kate, thank you, Maureen. So based on that, we have come to the end of the webinar. I really want to appreciate all of you for joining. I believe all of us have gained 1 to 2 from the same. It has been a very educative session for all of us. I will be able to share with you the slides and the Gazette notice that has been requested on your emails that you used to register. Apart from that, we can always say we are available to assist you at any time in case you have issues relating to the same. So apart from that, thank you. And yeah, we have come to the end of the webinar. Thank you so much for joining.